Good morning everybody and welcome to this morning's webinar, GDPR for your Payroll Bureau. GDPR is certainly the buzz term at the moment, and that's certainly for good reason. The scope and the impact of GDPR cannot be overstated, and it will affect most, if not all, areas of your business, and it will change how you manage personal data forever. So my name is Laura Murphy, and this morning I'm joined by my colleague Jennifer Hussey, who'll be popping in and out of conversation and help me along today. Throughout the webinar this morning, we look to peel back the legislation and the mass of reading material that is out there on GDPR, because there certainly is a lot, and you can certainly tie yourself up in knots Googling GDPR and all the different information that will appear. So I've highlighted some of the key areas that we're going to touch on today, and we've a busy schedule ahead of us, so we'll get going. And as always, we'll just work through the webinar this morning. Please, if you have questions, we'd love to hear them. Type them in as you think of them, but we'll answer them, and we'll have a Q&A session at the end when we get to the questions. Perfect. Okay, so first and foremost, what is GDPR? GDPR stands for General Data Protection Regulation. The GDPR, it's a European privacy regulation, and it replaces all existing data protection regulations. So at the moment, every member state has their own piece of data protection legislation. So from 2018, next year, all that will be replaced by the GDPR. It's an extremely significant piece of legislation, and as I said earlier, it will change how personal data is managed. I suppose the ultimate objective of the GDPR is to provide better protection for personal data. If you think about it, I suppose previously data was seen as an asset, and you'd look to build up your mailing lists, and that was, information was power to a certain degree. But now we're moving towards information and data being a liability in our organisations. So the regulation itself is a result of 4 years of work by the EU to bring the data protection legislation in line, with previously unforeseen ways as to how data is used. And I suppose if you think about that, the current UK data protection legislation dates back to 1998, and that predates the current levels of internet usage and cloud technology. So it really makes the data protection legislation that's in place today, it's totally out of date, and it's just unsuitable for today's digital economy. So really a modernized version really was required. So that's what the GDPR has been set out to cover all that the new way we use data. So before we get into the nitty-gritty of the legislation, I just wanted to give you some facts and snippets of information that we came across that I think highlight how data protection is getting out of control and how we use data. So just a little bit. Research done by the Information Commissioner's Office in the UK revealed that only 20% of UK public trust organisations that store data on them. If you look, data brokers collect more than 50 trillion unique data transactions per year. 82% of Android apps track your other online activities. If you were to read all the terms of service for all your apps, it would take 76 days, and I certainly haven't read all the terms of service for the apps on my phone. And then finally, PayPal's term of service is almost 37,000 words long, and that's longer than Hamlet. So I know I haven't read Hamlet either. So again, it just goes to show how data is getting out of control and why this GDPR regulation was required.
Okay, so GDPR D-Day. So the D-Day for GDPR is the 25th of May 2018. This is the date the legislation comes into force. So it is vital to remember that this is the day you must actually be compliant by. The regulations were finalised in 2016, giving a 2-year window for preparation. And as Laura said, it's been in the pipeline for the last 4 years. So realistically, at this stage, we've six and a half months to go. So if you haven't started to prepare, now is certainly the time to get going. The GDPR is going to bring significant legal and operational changes, and it is going to transform how businesses handle data. So as I said, the time is to prepare now, don't leave it until the 25th of May next year, because at that stage you're just going to be non-compliant on the first day. So reasons to pay attention. This is a massive, obviously, scope of it. So organisations can be fined with 4% of annual global turnover for breaching GDPR, or 20 million, whichever is the higher. This is the maximum fine that can be imposed for the most serious infringements, so the likes of not having sufficient customer consent to process data, or violation of the core privacy by design concepts, and we'll look at those a little later on. There is a tiered approach to fines, so a company can be fined 2% for not having the records in order, which is part of Article 28, not notifying the Supervising Authority, and data subject about a breach or not conducting impact assessments. So it is important to note that these rules apply to both controllers and processors. So you as payroll bureaus, i.e. processors, could be liable for these fines. And just to note that in the case of repeat offenders, penalties are cumulative and likely to be punitive. The other factors obviously that you need to pay attention to or bear in mind is that obviously you'll have the likes of brand damage, you could have loss of business, the cost of investigation, remediation, litigation. These are all things that are going to have an effect if GDPR breaches are found.
Yeah, that these fines, just to pop in there, Jenny, that they really are massive, and online research shows that if fined, over 50% of small businesses with less than 50 employees would close within 6 months of receiving that fine. So I think there's definitely reason to kind of sit up and pay attention.
Absolutely.
Just to move on there, because Jenny mentioned data processors and data controllers, so I just want to clarify some of these terms before we go on, because we'll be using them throughout the webinar. So just to clarify some of those terms, the data subject, so that's the individual who is the subject of the personal data. So I suppose from a payroll bureau point of view, the data subject would be the client's employee, because it's their information that you're processing. Processing means any operation which is performed on personal data, whether or not by automated means such as collecting, recording, organization, storage, adaptation or alteration, retrieval and consultation. So again, you are processing the payroll, that's processing data. If you're taking on a new employee and you're setting up them on your systems, that's processing the data. So a personal data breach, this means a breach of security leading to the accidental or unlawful destruction, loss, alteration, unauthorized disclosure of or access to personal data, transmitted, stored or otherwise processed. So your data controller then, the data controller controls the content and the use of the personal data. So for the payroll bureau, I suppose, the data controller will be the company, your client. And the controller means that it can be a person, a public authority, an agency or another body which determines the purposes and means for the processing of the personal data. And then finally, processor. This again, it could be a person, a public authority, an agency, or some type of other body which processes personal data on behalf of the controller. So as we said, in terms of offering payroll bureau services, you will be a processor and the employer will be the controller. Just what's kind of important to note here is that the GDPR for the first time gives processors significant responsibilities and liabilities on their own. So processors may now be held liable for damages or subject to fines and other penalties. Previously, it was very much the responsibility tended to lie with the controller, and the processor could kind of step away from a lot of the responsibility, but the GDPR now does place responsibility on the processor. So again, it's very important that you do step up and make sure that your processes are in line with the legislation. So we've talked about supervising authorities, and the supervising authority in the UK is the Information Commissioner's Office, so the ICO. And there's also a European Data Protection Board, and they oversee the supervising authorities in each member state. And then among other things, they will adjudicate on disputes that are escalated. I have to say the ICO have excellent resources in place to assist companies and bodies get ready for the GDPR. On the 1st of November, just gone, they launched a new helpline specifically for small organisations. they recognise that in the UK there are over 5 million businesses that have fewer than 250 employees. And when it comes to data protection, research shows that they do tend to be less prepared. And obviously so, you don't have the resources, you don't tend to be able to afford one specific person to take on a role just to look after data protection, where bigger companies may be able to do that. So that's why they've set up this helpline. I have to say again, it's excellent. The wealth of information on the ICO website is huge. If you haven't already visited, please do. I'd recommend it. So when we've given the details of the number here, and when you call through, it's option 4 that you want to go to. The ICO, I think they really set out their stall to assist small employers where they can. So who does the GDPR affect? It affects EU companies that process personal data regardless of whether that processing takes place in the EU. It affects non-EU companies who offer goods or services to individuals in the EU, irrespective of whether payment is required. So Facebook, that's offering a service, but you don't necessarily have to pay for it. And then non-EU companies who monitor individuals' behaviour that takes place in the EU. So Google would be an example of that. So we can see it's not only European companies that are going to be affected by the GDPR. It really is a global concept. And just to kind of just say here as well that we did this webinar previously, and somebody asked, well, I'm a sole trader, so is that going to affect me? Yes, it will. You're still processing personal data, so the GDPR will apply to you. And then also I just wanted to mention with regard to Brexit, the GDPR comes into force on the 25th of May, as Jenny has already said, 2018, and the UK will not have departed the EU at that stage, so GDPR will apply in the UK from the 25th of May. And following that, the Queen even referred to the GDPR in her speech back in June this year, and she stated that to implement the General Data Protection Regulation and the new directive, which applies to law enforcement data processing, meeting our obligations while we remain an EU member state and helping to put the UK in the best position to maintain our ability to share data with other EU member states and internationally after we leave the EU. So I think this is a further confirmation that the UK will implement a UK bill post-Brexit, which does reflect the GDPR framework. So I think very much the message is, still to get prepared for GDPR. There's no kind of way out, I suppose.
No, and another pointer following on from that, that further illustrates the UK commitment to data protection is that last year in 2016 there was 35 fines totaling £3.2 million. And these were served for breaking data protection laws in the UK at that point. So that makes Britain one of the most active regions for regulatory enforcement across Europe. And that was double the amount of fines that were issued in 2015. So, the UK certainly stands out in the EU at the moment, and I don't think Brexit is going to negatively affect that. I do believe that they'll still stick with that.
Yeah, absolutely.
So at this stage, we can imagine you're saying to yourself, what exactly is personal data? So the definition of personal data is any information related to a natural person or data subject that can be used to directly or indirectly identify that person. So it can be anything from a name, a photo, an email address, your bank details, posts on social networking websites, medical information, or a computer IP address. Now this is not an exhaustive list by any manner, so just bear in mind, all sorts of information, records of your websites that you visited, and the IP address, as I just said as well. So do you hold any of that type of information in your company? Of course you do. So whether it's your client's information, your customer information, or your employee data, somewhere along the line you will be dealing with personal data. And the GDPR will apply to your company, and you do need to be aware of the particulars of this new regulation.
Okay, so we move on to some of the key areas of the legislation now.
Okay, so there's 6 principles of the GDPR. So under current data protection legislation, we have 8 principles of data protection. This has been reduced to 6, but certainly none of the content has been lost by that reduction. So under the GDPR, personal data shall be processed lawfully, fairly and in a transparent manner, collected for specified, explicit and legitimate purposes and not further processed in a manner that is incompatible with those purposes. It shall be adequate, relevant and limited to what is necessary in relation to the purpose for which they are processed. It shall be accurate and where necessary kept up to date. Every reasonable step must be taken to ensure that personal data that is inaccurate is erased or rectified without delay. It must be kept in a form which permits identification of data subjects for no longer than what is necessary. And it must be processed in a manner that ensures appropriate security of personal data, including protection against unauthorized or unlawful processing and against accidental loss, destruction or damage, using the appropriate technical or organizational measures. The overarching principle here is that of accountability. So you really need to be able to demonstrate compliance with these principles, and that kind of lays more so that the kind of burden of proof is going to be on you to be able to prove this accountability.
That just was one of the biggest changes with GDPR. Previously you had to be compliant with data protection legislation, but now you have to be compliant and you have to be able to prove that you're compliant. So that body of proof is what's different, and that's the accountability aspect, and that's kind of one of the key changes. I suppose we've talked to a number of different bodies, and our kind of overriding opinion is that if your company is meeting the obligations under the current legislation, hopefully then compliance with the GDPR should not be too much of a change or too onerous. It's just about building that your body of proof up, I suppose.
Okay, so if we look now at the reasons why you can process data. So what is lawful processing? So processing data is only lawful if the data subject has given consent, and we'll come back and look at this issue shortly. If it's necessary for the performance of contract or to take steps prior to entering into a contract, so in your case you more than likely will have a payroll contract with your client or your employers. It's only lawful if it's necessary for the compliance with legal obligation to which the controller is subject. So in this case, for tax purposes, the employer is legally obliged to keep their taxes up to date. That's going to be your role as the processors. It'll be lawful in order to protect vital interests of a person. So the likes of health records there could be an example. If it's necessary for public interest or official authority. So this would be more likely to refer to the likes of the public sector bodies. And it's only lawful if for the legitimate interests of data controller or yourself, the employer in this case. And this really is where you can have a little bit more flexibility in classifying your processing. So the likes of, your, I can't think of the word now, your coding notices, giving the employees kind of tax details that you would receive on behalf of those employers. So when you are reviewing the data that you process and you're asking yourself, is it lawful for us to process this data? These are the key points that you need to be looking at to ensure that.
Yeah, you need to be able to tick off one of these points that you've just mentioned. Okay, so Jenny talked about consent. So if you're going to rely on consent in order to process data, that's going to be the lawful reason why you're going to process data. You need to be aware that there now is an elevated threshold for consent. So consent must be informed, it must be specific, and it must be freely given. There must be evidence that clear affirmation action has been given to. So you must, again, it's about that proof. You must be able to prove that somebody consented. And it must be for a specified purpose. So again, we can't have no one-size-fits-all options. They're no longer permitted. Where you are obtaining consent as part of a larger document, so maybe as part of your larger T's and C's, and so other things are covered in that document. The consent text must be clearly distinguished from everything else, so almost in its own section. If you're asking for consent, it needs to be on its own and very clearly marked and highlighted. Evidence needs to be retained, so I just mentioned this as to how the consent was obtained. So for example, if it's forms, brochures, signage, website screenshots, however you're going to be able to prove that. The language that you use in obtaining that consent must be accessible and easily understood. So there's no more tolerance for legalese. The language, so when you're talking about your privacy policies now and you're explaining to people what you need to do, or when you're asking for consent, it has to be in a very easy to read language, no legalese. And this is particularly so in the case if you're obtaining consent from persons under 16. But we'll talk about that again, and we'll touch on that a little bit later. So I suppose in terms of your payroll bureau, you may need to rely on consent for any marketing material that you may send if you're sending company newsletters. In terms of processing your payroll and the actions of doing the actual payroll, I think you'll be relying on some of the other points that Jenny talked about, you know, in terms of the contract and the legal needs. So you won't need consent, but if it is that you send out monthly newsletters, flyers to people, then you might need to look at getting specific consent.
Okay, so we've looked at your personal data. So now that there are special categories of data which will include personal data, which will reveal the likes of your racial or ethnic origin, political opinions, religious or philosophical beliefs, if there's trade union membership, the processing of genetic data, biometric data for the purpose of uniquely identifying a person, data concerning health, or data concerning a natural person's sex life or sexual orientation. So there are additional requirements for the protection of this kind of sensitive personal data as well.
Yeah, so when Jenny talked about the lawful reasons why we might process data, if you're processing any of the above named data here, you're going to have additional requirements. It's an interesting one because it's one that we actually, well, we came across it on the phones not so long ago. Biometric data, and then one of our customers was using employee clock in and clock out with a thumbprint. So a thumbprint will be considered biometric data. So if that's what you're using in your workplace now going forward, you just have to take a little bit of caution and consider what are my legal reasons for processing that data. So we'll talk about employees in future, because when we talk about dealing with the special categories of sensitive data, some of the extra requirements that you need would be specific consent. Unfortunately, you can't rely on consent in an employment situation because the balance is uneven, I suppose. So consent is not considered to be freely given in an employment situation. So you're going to, if you are using biometric data or thumbprint, handprint, log in, log out, you just have to be very careful. And I think at the moment you're going to have a really strong legal basis as to why you require that. Now there is an exception that says member states might bring in their own pieces of legislation on this. We haven't seen that yet, and we're still waiting on it. So again, at the moment, I think it's just something to be very aware about and be very careful if you are doing biometric. And some companies might ask for consent to employees, and if employees don't want to give consent, then there's an opt-out option. There's another alternative way as to how they might log in, log out. But that's just a little note on that.
Okay, so children's personal data. So the GDPR contains new provisions intended to enhance the protection of children's data. It's probably not going to impact you and your payroll bureau, but we'll just run through it quickly as a matter of interest. So the GDPR states that a child under 16 can never give consent themselves. Parental consent will always be required. Now, member states can lower this themselves, but never beyond 13 years. And it is believed the UK will have a digital age of consent of 13 years. So if you do have services that are directly offered to children, you will need to be extra vigilant that your privacy notice and policy is written in a clear and a plain manner that a child of 13 years and over will be able to understand.
Yeah, I suppose this is probably more so coming from the Facebooks and the Snapchats and all those kind of social media areas that children are using, but it's an interesting point, especially if anybody is a parent out there, so it's worth saying. Okay, data protection by design and by default. Under the GDPR, you have a general obligation to implement technical and organization measures to show that you have considered and integrated data protection into your processing activities. The concept of privacy by design and privacy by default, they're not in the current legislation, they're not current legal requirements, but they are seen as best practice. But now there's an obligation that they come into your day-to-day business, I suppose. So to define them, privacy by design, it seeks to ensure that privacy issues are considered at the outset of a project rather than being an add-on at a later stage. So really what we're saying here is that privacy should be embedded into the DNA of the organization. So as much as you're taking on a project or you're doing a new piece of business and you're making your business plan and your marketing plan, your financial plan, your data protection plan, or that piece of the project should be included right from the start as well. And privacy by default means that by default only such personal data as is necessary for the identified purposes should be processed. So you're not retaining or holding on to any data that is not necessary. It's really about minimizing the data. So again, what we're talking about with data protection and data protection by design and by default is just a way of doing a business and approaching business, now putting data protection at the core of what you do. So then to move on to the data protection impact assessments, so DPIA, or they also could be known as a PIA, you might see them referred to as either or. So the GDPR brings in a new requirement to carry out a risk assessment when you're using new technologies or when the processing is likely to result in a high risk to the rights and the freedoms of individuals. So this might include if you're starting to do automatic profiling, if you're doing large-scale processing of special categories. The GDPR sets out specific information that you need to look at and you need to assess in your DPIA. So if you are required or you do feel it's necessary to conduct a DPIA, you'll be looking at a description of the processing operations and the purposes of that. You'll do an assessment of the necessary and proportionality of the processing in relation to the purpose. You'll do an assessment of the risks to the individual, and you put measures in place to address the risks, including security, and to demonstrate that you're compliant. So, it's not going to be possible to remove all risk, but certainly you'll look to minimize risk. And where there is a substantial risk identified in your DPIA, then you must refer that to your supervising authority, or for most people here today, that will be the ICO. Okay, we want to move on to the enhanced rights for individuals, because under the GDPR there are new and enhanced rights for the data subject. So these will include the right to be informed. So this emphasizes the need for transparency in how you use personal data. And again, we talked about accountability earlier and proving that you're compliant. Transparency. Accountability and transparency are two of the big kind of buzzwords when we're looking at GDPR. So you need to have transparency. You must be very clear with data subjects about how their data is being used. So this will be your policies, your privacy policies that you have on your website, or setting out in your contracts with your controllers, with your clients, exactly how you use their data.
Perfect. Some more of the enhanced rights for the individuals will be the right of access. So the subject can request access to the data that you have on them. Now the time frame for the response to that access request has been reduced. So currently it's 40 days, and so that's been reduced down to 1 month. So if the request is made electronically, you should provide the information in an electronic format. The fees have been removed, so today's company can charge £10 for access request information, but under the GDPR there is no charge.
You understand that there are different fee arrangements for organisations that hold certain other kind of information, whether that be credit, health or education records, and they have different fee arrangements. But I think for the most part, and for our attendees today, you're looking at the £10 fee reverting to zero.
Yeah. In relation to that, then the processor can refuse the request for the right to access if it is manifestly unfounded or excessive. So that'll be up to the processor or the controller of the actual data to decide whether or not.
Yeah, I think it'd be extreme cases where you would rely on that. An interesting point as well that the GDPR makes. It introduces a new best practice recommendation. Now, so this is just a recommendation. They haven't set it out as law, but what they said is where possible, organizations should be able to provide remote access to a secure self-service system which would provide the individual with direct access to his or her information. This won't be appropriate for all organizations, but it will be for some. Now, I'm not sure for yourselves in terms of having a self-service secure system for your clients' employees, but you're certainly for your own employees, or you could, even if you think about Connect, our Connect product, in terms of that being a secure self-service system that employees can log in and see their data at any time, anywhere. And again, that's all to help transparency and people having the right to access and to be informed about what information is held on them, and then having the ability to have it changed or rectified, which are some of our next points. If we just move on to that then. So it is the right to rectification. So individuals are entitled to have personal data rectified if it is inaccurate or incomplete. So that's an existing right. It hasn't really been enhanced or changed. One that has been enhanced is the right to erasure, also known as the right to be forgotten. So the broad principle being that an individual has a right to request the deletion or removal of personal data where there is no compelling reason to retain the data. So if you do need to retain the data for legal or as a legal obligation, whether that be tax responsibilities in terms of payroll, then you have to hold on to the data. But if there's no compelling reason as to why you need to hold on to the data and a data subject has requested it to be erased, then you must erase it.
Okay. The individuals now have an enhanced right to restrict the processing. Now, you would still have to have the ability to retain the data, but they can restrict it to a certain point. There's also the right now to data portability. So this allows individuals to move, copy or transfer personal data from one IT environment to another in a safe and secure way. And this is commonly done in the likes of the banking industry, for example.
Okay, so then you have the right to object to the processing of their data. So this, I think the best example again here is for direct marketing purposes. If you have a mailing list for marketing purposes that you're sending out a newsletter every month to, and you must inform individuals. We spoke earlier that firstly you must get their consent if you want to send them that mailing list, but also at the time of gaining consent you must inform individuals that they have a right to object at any point, to object to the communications and to remove themselves from that marketing list. And then when you are providing the information to them and sending them the newsletter or whatever it may be, that on that it's easily done for them to untick and to unsubscribe and take themselves out. And then finally, rights in relation to automated decision making. So automated decision making relates to any form of automated processing intended to evaluate certain personal aspects of an individual. So this would include health, work performance, economic situation. And so where an automated decision making exists, individuals have the right to obtain human intervention, and they have the right to express their own point of view, and they have the right to obtain an explanation of the decision and challenge it if needs be as well.
The GDPR introduces a new best practice recommendation as well, that where possible. Oh no, sorry.
That's just our self-service point that we've touched on earlier, so I think we've...
Oh, right.
So where possible.
Our little sales pitch on our BrightPay Connect. If anybody wants to see it, it's on the BrightPay website.
Perfect. So we'll move on to breach reporting. So this is, again, it's a new duty on organisations to report breaches to relevant supervisory authorities, i.e. your ICO, and in some cases to the individuals affected. So a data security breach is very widely interpreted, but generally a breach means a breach of security leading to the destruction, loss, alteration, unauthorized disclosure of or access to personal data or human error. So it is much more than just losing personal data. So again, an example might be a hospital could be responsible for a personal data breach if a patient's health record is inappropriately accessed due to a lack of internal controls. And I think there have been cases in the UK as well of a supermarket chain, I can't think of the exact chain, so I'm not even going to guess and say and get it incorrectly, where payroll details were actually inappropriately accessed as well. So that would be a data breach for yourselves. Breaches must be reported to the ICO, but only, however, where the breach is likely to result in a high risk to the rights and the freedoms of the individuals. So, for example, that might result in discrimination, damage to the reputation, financial loss of confidentiality, or any other significant economic or social disadvantage. And I think there is a case to be said that a payroll data would possibly, if there's a loss or breach in payroll data security, that would be a significant right to the freedoms of an individual.
Absolutely, yeah. I think, well, very kind of high profile at the moment is the Paradise. Is that what they're called, the Paradise files?
Yes.
Just in relation to the kind of offshore tax havens that certain people have been using of late, that would be deemed, I imagine, the ICO would probably have quite a big say in how that would go down, but that's quite high profile there at the moment.
Yeah, absolutely. So, it's the bigger situations, a breach of, a small thing where a smaller internal process that wasn't maybe fully complied with, that might not need to be reported. But where the breach does need to be reported, it should be reported typically within 72 hours of becoming aware of the breaching, and that's a new piece of legislation that's come in with the GDPR. Breaches that are likely to result in a high risk to the rights and the freedoms of the individual must be reported to the individuals concerned. And so we'll just note here that the difference is that high risk. And the high risk means that the threshold for notifying individuals is higher here than for notifying the relevant supervisory authority or the ICO. And again, as I said, you have the 72 hours notice in which you need to report the breach. Failure to report a breach when required could result in a fine as well, as well as the fine for the breach itself. So you could see yourself doubling up on your fines, which we've already seen are quite significant. So
an expensive mistake.
Yeah. So I suppose in terms of preparing for this, you need to ensure that staff understand what constitutes a breach and that you have an internal data breach reporting system in place, however simple that might be. But for example, it should be predetermined as to who will make the final call on notification to the ICO and who makes the final call to the data subjects and notification to the data subjects. So you need to be at all times aware of what data you store, what data you're processing, and the security in place around that data. So just really before we move off the whole topic of breach reporting, so just in terms of preparing yourself for a breach, and the GDPR kind of and the readings on it say it's not if but when, because it's near impossible to prepare for every eventuality. So when a breach does happen, I suppose 4 key aspects to look at is to contain it and how to recover that data or fix it as quickly as possible, the assessment of an ongoing risk and how that might be preventable in future, the notification of a breach, you need to notify the relevant people, and then kind of any post-mortem or follow-up and responses that need to take place.
Absolutely. There was a case there recently in the UK of the communications company TalkTalk, where the ICO ruled that TalkTalk failed to make appropriate technical and organisational measures against the unauthorised or unlawful processing of personal data. So it was something to do with I think it was a virus attack or something that they had, and basically there was some kind of patch which could have been used to combat or to fix it, which hadn't been applied, and basically it resulted in kind of lack of up-to-date software, and then contact details of like 160,000 customers with bank account details were basically accessed. The ICO said that TalkTalk's failure to implement the most basic cybersecurity measures allowed hackers to penetrate their systems with ease. Yes, hacking is wrong, but that is not an excuse for companies to abdicate their security obligations. TalkTalk should and could have done more to safeguard its customer information. It did not, and we have taken action. And they were fined.
Yeah, this is what I find interesting about this case is they were fined at that stage £400,000. However, if this case had come up in the GDPR era, they would have been fined £35 million. So that's
a bit of a jump.
Bit of a difference.
Yeah.
Okay, we'll move on.
Right, so we're going to look at now the Data Protection Order, the DPO. So this is a new role that's going to come into effect with the GDPR. So the main role of the DPO will be to monitor internal compliance with the regulations. So it's going to be mandatory to appoint a data protection officer for the likes of your public bodies, organisations engaged in large-scale and regular systematic monitoring, organisations whose core activities consist of processing special categories of data or data relating to criminal convictions. So that could be the likes of the Metro and the Metropolitan Police. And it may be mandatory in other contexts as defined by the member state law. So again, the individual member states may appoint other specific mandatory options as well. So the data protection officer must have expert knowledge of data protection law itself. So it's not a case of just picking somebody out of a hat and saying, right, you're going to be the DPO. They have to have knowledge of the actual legislation. And they must be fully involved in a timely manner in discussions of personal data processing. So they have to be kept up to date with any of the processing.
And it goes by your data by design and data by default.
Exactly.
By default are involved at a high level of all decisions that are happening.
Exactly. They must not have any internal conflict of interest. So the HR, the finance manager, being appointed the DPO probably isn't going to be appropriate. They should be sufficiently senior to implement obligations. So they're going to need to be able to report to the highest level of management. It doesn't have to be an employee. And more commonly, I'd imagine it's going to be outsourced. And a group of organisations can have one DPO. So if you have a number of, kind of offices or premises, you may just have one data protection officer that will oversee all of them.
Yeah, I don't want to give a blanket statement here, but I would imagine a lot of our customers here today or attendees today are smaller organisations who the DPO may not be necessary in your case. Now, again, that depends on how large the organisation is and the amount of data that's being processed. But I would imagine for a lot of payroll bureaus, you possibly don't require a DPO, but it's good to be aware of it again. Anyway, it's really whether you do or you don't require one is probably best done on a case-by-case basis and just looking at your own organisation.
Another thing to be aware of as well is now the inclusion of civil liability. So individuals will now be able to take data controllers and processors to court to claim compensation for material and non-material damage. So this means compensation could be handed out for the likes of distress, hurt feelings, reputational damage, and even if there is no proven financial loss. So if you do have a GDPR breach, on top of the 2 and the 4% of your annual turnover fines that we've already touched on, you could also face civil case litigation with additional fines on top of that. So
just the news keeps getting better.
I know.
Okay, let's move on and look at start preparing what you need to do. As a first step, you should review all personal data that you hold. So you want to complete a data inventory, whether that data relates to current or former customers, current or past employees, unsuccessful job applicants, or other third parties. It is recommended that when you're doing this data inventory that you record all data under the following headings. So you want to look at why are you holding the data, what is the legal basis, and that's going to be what are the lawful reasons for holding that data. How is the data obtained? Why was it originally gathered? How long is the data held for? How is the data saved? Is it done securely? Is the data shared? Is it shared with a third party? With whom is it shared? As the GDPR requires organisations to be in a position to demonstrate compliance with its requirements, and we've talked about that accountability and need for proof, documenting all the above will enable employers to identify gaps in your compliance, firstly, and it will enable you to put in place processes that rectify gaps, but it'll also, I suppose most importantly, it'll be that evidence of compliance with the new GDPR that you're building this database of all the database of your data. But what we've done even internally here at BrightPay when we started to do our own data inventory, it was a simple thing as an Excel spreadsheet, and we just listed on the top all the headings that we wanted to complete. What was the data that we held? What were the reasons we were holding it for? Is it secure? Who did we share it with? And then was there any action that we needed to take in order to kind of become fully GDPR compliant? And when we were doing that, we broke our spreadsheet into different worksheets. So we had our customer one of the data we hold on our customers, then we had our marketing one, then we had our employee page, and then we had just the other third-party organisations that we work and might share data with as well. So that was really useful for us in terms of making a priority as to what areas we needed to look at first. And we found now that a few months on in our preparation, we really use this document as our go-to guide, and it's always changing. And I think that's one of the things with GDPR. It's, you do a tick list, but you don't just park it there and leave it. It's something that is going to be always being referred back to and changing and developing. But we found that our Excel spreadsheet has really helped us focus our plan. So that's kind of where I would start if I was you, just getting all your data listed. And we did it. We had to talk to everybody in the organisation, and something different always popped up depending on who we were talking to.
Just in relation to that point, just going back to the kind of preparation for the GDPR and starting now, as Laura said, like we started a good while ago, but over the months, our processes have changed, because we can see like that you mightn't necessarily have seen a gap at the beginning, but further down the line you kind of learn more, and you see more instances where you can make better arrangements to make yourself kind of more compliant. So that's why it's key to start your preparation now and not leave it until too close to time.
Yeah, it's an evolving thing.
Yeah.
But don't take it all on one person. If you're a small company, get 3 or 4 people in a room. Everybody will have a different thought, they'll have a different input into it, and it really is something that we found that we needed a lot of people involved in. It didn't take too long to do, or people did it over a matter of time, so don't be daunted by it. I know it sounds like a lot, but once you kind of get into it and get started, it wasn't so bad. The next thing that we did and we recommend you do is your data privacy notices. This is that you review your data protection notices and analyse whether they require any updating to ensure compliance with the new rules. And if you don't currently have any data protection or privacy policies in place, you really should start to look to put these in place. So when collecting personal data, the GDPR requires businesses to provide detailed information to individuals, and we've set out the information that you need to include in your privacy policies here. So in a lot of websites, our website at the bottom would have a privacy policy, so you may want to put a privacy policy on your website, or when you're going into business with your data controllers, your clients, that contract is going to be very important, and you may need to be sure that you've got this information and you're notifying your clients about the information that you hold on them. So the GDPR requires that you include certain information in your data privacy notices, and I've listed them all here. I'm not going to go through them all with you. I'm going to go through a couple of kind of key ones, but they're all here and you'll get them on the slides later. So definitely when you're doing up your privacy notices, use this as your tick box, if you like, going through it. So just a couple that I wanted to that I've highlighted. You need to specifically state whether or not the data will be transferred outside of the EU. Now, whilst the GDPR is not saying you cannot transfer data outside the EU, certainly you are going to, and the way we do business now is, data is constantly being transferred in and out of the EU. But where you do transfer data outside of the EU, you need to specifically notify the data subjects that that's what's happening. And where you do, again, transfer data outside of the EU, there's just a higher level of data protection that you need to ensure exists there as well. So it's something to be aware of. And then the second point I just wanted to say there, you need to notify people of the period of which the data will be stored, or the criteria to be used to determine the retention periods. So how long are you going to hold the data for? Now, the GDPR doesn't set any time limits on how long data should be held for, because it's going to be very specific and it'll very much depend on the data itself that you're holding and why you're processing it. So a lot of your data is going to be payroll data, and for legal reasons you're going to need to hold that for 6 years or so. So, you know, maybe that's what you specify. Maybe you need to hold on to certain information for longer when you're looking at your employee records, your own internal employees. Well, there's certain different types of, you know, how long you hold on to holiday leave records, how long you hold on to disciplinary records. That's all specified in employment legislation. So I suppose you'll be led by the different areas. But again, it's very important to clarify whatever data is you hold, how long are you going to hold that. It might be on a case-by-case basis, and you just need to make that clear in your privacy policies.
Okay, so there's further preparation obviously you can do as well, and we've touched on the basics there, but the likes of, you know, your contract. So in your instances, the contract between you, the data processor, and the employer being the data controller.
I think this is a really important one at this point, particularly when we're looking at the increased responsibilities that data processors have. So I think I would recommend as a payroll bureau and a data processor to go back and have a look at the contracts that you have in place with your customers, and there is certain information there that needs to be in those contracts, and the GDPR specified that as well. Now, the GDPR puts the onus on the data controller to make sure the contracts are in place. I don't know if you want to, you know, I think maybe it might be best practice as a data processor to take, you know, to take steps to organise that, but the onus is on the controller, so I'll leave that there with yourself.
So as Laura's pointed out, you need to obviously clarify the risk between, you know, both parties. You know, are you going to be processing children's data? You obviously need further preparation for that. Will the requests to access, will that change? So we did touch on that briefly there. That's going to change slightly in regard to you no longer will have 40 days to get the access or the request to them. That's been reduced to 30 days. And you won't be able to charge for that data request.
Or can you provide that information in an easier way, perhaps on a self-service portal in some way?
Like Connect.
I didn't say that, you did.
How will you manage breaches? And then going back to your data by design, your DPIA, so, you know, your risk assessments there. Do you require a data protection officer? You know, so there's a lot of things that you can kind of look to, but as Laura said, don't be daunted by it. A lot of stuff is already in place.
It's just a matter of kind of documenting it.
Exactly. Review what you already have there, and then, you know, establish what you need to do to make yourself compliant.
We've kind of got our approaches here is we're building up our GDPR Lever Arch folder or our online Dropbox folder, you know, everything that we've done, all the steps that we've done to become GDPR compliant. We're building that up and we're putting it in our folder. So, you know, if anything ever did happen, we have this body of evidence that's there, and that's our proof and our mitigating circumstances. So that's my advice as well, is to look to just start building that up and document everything, log it in there, and just build it up and protect yourself as much as possible.
Absolutely. The likes of, as Laura pointed out, the ICO website does have a huge amount of helpful guidance there for you as well. So, you know,
I'm just going to skip, I'm going to come back to this slide here, but I'm just going to skip to the next one. This is, I find it, this is the ICO, just as Jenny's mentioned it. The ICO have developed a 12-step guide as to what you need to do to prepare. We've talked about a lot of this already throughout the webinar. The first one is awareness. You know, you're all on the webinar today, so you're kind of ticking off that first point of becoming aware already, and then it's the information you hold. And you know, this is available on the ICO website. I'd recommend everybody to go and have a look and to start working through it, and to use that helpline as well. That they offer. It's definitely a great resource that they do offer. But I want to go back just very briefly to touch on GDPR from a HR perspective. Now, so we're kind of moving internal in your company here, so it's not really, this is not going to apply to your dealings with your clients and their employees, but I would imagine a lot of you are here today are employers, whether it's 2 or 3 employees, and the GDPR, there is some kind of implications and considerations to be aware of, I suppose. So data in the employment context, that will include information in an employee's personal file, information held on a HR system, information contained in emails, and information obtained through employee monitoring. So when we talk about GDPR and HR, it's really all the same concepts that we've already discussed, but I just wanted to touch on a couple of different points. Lawful processing, and we've already touched on this on consent. So Jenny listed out the reasons why you can lawfully process. Consent is not going to be permitted from a HR point of view, and up until now it probably was one of the more commonly relied upon grounds. But under the GDPR, as we said earlier, consent must be freely given and it must be specific and uninformed. So again, given the imbalance of power between employees and employers, it will be difficult for consent to be freely given, which means it is unlikely to provide a valid basis for processing HR data. So a term then that Jenny used, and a term in a standard employment contract will certainly be insufficient to, a term in a standard contract of employment will be insufficient. What you're going to need now is to build a proper data protection policy outlining to your employees clearly what data is held on them and why you're doing it. Legitimate reasons or lawful reasons why you might rely on in terms of employee data might be the legitimate interests of the business, and that's going back to the point that Jenny made earlier, being that little bit more flexible. So you might rely on processing HR data for the legitimate interests of the business. There's a commercial benefit, and it might just be in terms of performance management. That's a legitimate reason. It's a business reason why you're holding on to that. And then obviously necessary for the performance of a contract or to comply with a legal obligation. So a lot of HR data will be payroll data, and you're holding on to that obviously to be able to pay them and to meet the contract. And again, obviously, then the other thing that I've just been mindful when we talk about HR is the increased employee rights with regard to the right to information. Employers will need to provide, again, as I just mentioned, more detailed information as to how and why the processing of HR-related personal data is done. So it's a long list of information to be provided, but again, it's all about providing that transparency. So I just wanted to touch on the HR side of it. Okay, perfect. So we'll move on now to what we've done and how we've prepared, I suppose. And data protection has always been a concern for BrightPay, and we've always aimed to act with complete integrity in this regard. But I suppose, like all companies, we've had to sit down and take stock and look at what we are doing in light of GDPR to ensure that we can be GDPR compliant come May next year. So kind of we've touched on it earlier, but I think the process of doing that has been quite interesting. And looking at some of our processes, we realised that perhaps they weren't the most efficient, and then we took the opportunity to improve how we did things. I suppose again we've kind of touched on this again, but our thoughts on data now is that it has become something of a curse, and really we only hold minimum data and we just get rid of it as soon as we can, really. And thank God we don't hold a huge amount, really. For example, we don't hold customers' credit cards, bank details, so we don't need that. We do hold names and addresses of customers because we're obliged to keep them, otherwise we'd probably delete them as well.
Absolutely. I think you're going back to the statement there that the data has become a liability as opposed to an advantage, an asset now. Yeah, that's it. I think as well, we do come across it on the phones as well. The question has been asked a number of times. We don't have access to your data files. So except in the instances where you've sent us a backup for support reasons, so we don't have any control over the authority or the quality or the safety of your data input. That's down to you, the processor. So you and you alone are responsible for the accuracy and completeness of your own records. So whilst we do have security measures in place to protect your data, obviously with the likes of your password protection, all of the information on our systems are encrypted. It does, fall back on you and remains your responsibility to keep your login details, your sign-in details secure and secret. So just kind of ensure that you are kind of closing out of the system, that you're logging off BrightPay or Bright Contracts when you're finished using it, and just make sure that there's no unauthorized access to your machine. That is, your own responsibility.
Okay, so what have we done? I'd like to go through some of the key changes that we've made that will affect our customers. So one of the key aspects that came out of our data inventory list was that from time to time when assisting with an employee query, as Jenny has just said, in order to fully resolve the query, the only solution for us is to request a backup. So we will take your data file at that point. And whilst we did have security protocols in place for this, we felt that we could make them even more secure. So what we've done is we've created an in-program software feature that allows users to automatically send a backup of their payroll to us through a secure channel. So the benefits being that you don't have to upload the backup to your email where you may forget to delete it, but mainly on our side, the backup never gets saved on one of our employees' PC or their emails. It's all saved centrally here on a secure server, and then it's automatically deleted after 1 week. So this particular feature was included in our recent year-end upgrade. On the BrightPay UK side. Yeah, it was in a recent upgrade, and it'll be, of course, in our 2018 software. So I think it's a really powerful tool that we've put in.
Absolutely, yeah. Like, you deal with a lot of customers on a daily basis, and unfortunately, some cases can't be just fixed over the phone. So we were, and do deal with quite a lot of customer backup. So it's a really secure feature that ensures customers know that it's been deleted after a certain period of time and it's not kind of floating around anybody's desk.
Yeah. We're also currently finalising our privacy policies, and these will be going live on our website shortly. The new policies make it really clear to all our customers and to any individual whose data we process. It makes it really clear how we use your data, who we share it with, and how long we keep it for. So we really worked hard in keeping the wording plain and simple as well for that. We, removed all legalese. I think they're good policies, so they'll be going on the website in the near future.
Sorry, just back to the first point, we have actually added increased encryption of the data files. So just in case, God forbid, you did have a virus or a hacker that manages to access your files, there's massive encryption on those files, so it's highly unlikely that they would be able to break that. So our third point then is similar to what we said about deleting your HR files. We've actually completed internal audits, IT audits on all of our PCs here. So deleting any unnecessary data. Going forward, our plan is to run these audits on a regular basis, and it's a great way for us to actually keep track of all the data that we do hold and ensure that we're not retaining anything that is unnecessary as well.
Yeah, and I think that's a really good process. That habit, yeah, data by design and default. We have looked at how information is sent to and retrieved from our secure servers, be it for the purposes of maintaining our websites or our CRM system, and we've now changed all of our servers over to the more secure Microsoft Azure servers, and we've also introduced IP whitelisting, meaning that knowing the login credentials is no longer enough for our CRM servers. The request must come from a trusted location. So again, that's just adding extra security internally.
We've introduced extra consent fields in different areas of the software and on our websites as well. So going forward, with the exception of essential software updates, customers will not be contacted, unless they have specifically opted in to receiving contact information. Although I would say that our newsletters and webinar invites are quite informative. So I would certainly say it's worthwhile giving consent, and you don't want to miss out on these fabulous webinars.
I'm sure you all agree. Coming to a close, our staff training, we will be holding staff training and update sessions to ensure our staff are fully aware of the new legislation and how it impacts their role. And then finally, Bright Contracts updated policy. So if you are a Bright Contracts user or you're using it for your clients, we're in the process of rewriting our data protection policies, which again are really important in terms of being transparent with your employees and telling them what information is being held and why. So we're updating our policies there, and they're going to be released in the near future as well.
And if you're not using Bright Contracts, maybe you'll just take a look on the website for that as well. It's a very handy contracts and staff handbook piece of software, brightcontracts.co.uk.
Absolutely, and we do hold regular demos if you just wanted a quick demo on it as well. Okay, so that brings this section of our webinar to a close, and I really think the final message will be just to be aware, to get prepared, and ignorance really won't be a defence come the 25th of May next year. There's no excuse. Get prepared. I'm looking over my shoulder and I can see that there's lots of questions coming in, so we're going to move over to take your questions now. So just bear with us while we get set up and get open with those questions. I just see one question coming in whilst Jenny is opening. It's just, as a bureau, do I have to get permission from each of my clients' employees to process their payroll? No, no, you don't. Is the simple answer, I suppose. What's important from the payroll bureau point of view is that you have a strong contract in place with your customer, the data controller, and then it'll be the data controller, i.e. your customer, the employer. It'll be their responsibility in their employee policies and procedures to clearly notify employees where their data is shared and who it's going to. Okay, is there any other...
Well, there's lots of people asking about the slides. So anybody who has registered for the webinar will receive a copy of the presentation itself along with the recording of the webinar at some point today. So don't worry about that, you will get them. So just moving on to...
Just see when there is a business email address classified as personal data. Yes, it is. So my email address will be laura@brightpay.co.uk. So if you can see Laura@BrightPay, well, you know that's Laura that works in BrightPay, and you can then figure out that that's me and that's my personal data. So my email address, although it's my work email address, is personal data. The email addresses that are admin@BrightPay, info@BrightPay, they're not personal data, so there's a bit more flexibility there.
Somebody's asking there, how long do we need to keep the payroll data? So legally, payroll records must be kept for a minimum of 3 years from the end of the tax year in which they relate to. So as payroll bureaus, anything relating to the likes of statutory pay details, tax information, and they all need to be kept for 3 years for HMRC purposes.
So somebody who does payroll for their clients, and the client keeps the payroll details on their software. Do our clients who do not keep their employees' details need to register for GDPR? Well, it's not that you need to register for GDPR. You have to become GDPR compliant, and that's all companies. They must process that data somewhere in order to give you, as a payroll bureau, the data.
There's a couple of questions there just in relation to employees under the age of 16. So yes, anybody under the age of 16, you need to get parental consent. Yeah. So it is 16. Yeah. Anybody under the age of 16, they cannot give consent themselves. Their legal guardians or their parents will have to give you consent or permission as such in whatever regard that you're looking at. Okay, so again, for children under the age of 16, filling out new starter forms, some clients do employee under 16 forms. So do the employees need to sign the form still, or do we need parental consent to use this data as well as for the payroll? So again, once they're under that age,
I think you're better off as just a safe, as I said, the UK could bring in different legislation. At the moment we haven't seen that yet. They're saying they're bringing online consent to be 13. obviously what you're talking about here isn't online, I would just be to be on the safe side, I would ask for the parental consent.
Regarding fees for the right to access, as agents for the client, can we charge the client for the time spent if we have to give them information requested by their employee?
That's probably more of a question in relation to your contract between you and your client, but you certainly can't charge the employee who has requested the data. I know you're talking about billable hours that you put in for your client, and I'd say that's probably a matter for you and your client really to have in the contract. The right to erasure versus keeping business records for HMRC, say for 6 years, which takes priority. The business records, HMRC, that takes priority. That's the legal reason, so that would take priority there.
So in terms of reporting errors for payroll, if wage slips were accidentally emailed to the wrong client, would we have to advise each employee that their wage slips had been sent to the wrong place, or the employer of those employees? Well, I'd imagine the first people you would go to would be your controller, so that would be the employer. I'd imagine the employees will already know if they've got somebody else's payslip at that stage. This, I suppose, is kind of questionable in relation to, would you report this to the likes of a data protection officer?
If it's the pay slip, I'm thinking we go back to why do you need to report a data breach? You need to report a data breach if it, what was the wording now? If it's considerable, if it's going to pose a considerable considerable risk to the rights and freedoms of the individual.
Yeah.
Now,
high risk.
High risk. I don't know what the high risk would be of a pay slip. It's just a pay slip. If it was more detailed information,
bank details or something like that.
Yeah, if it's a name and an NI number, then that could possibly be a high risk. I would certainly say it's a risk in terms of reporting to the ICO. The high risk, that probably, again, this is on a case-by-case basis, and you probably go for guidance then from the ICO on that one.
Again, we're all kind of learning, as we're going along. So, as we said, the ICO has a huge amount of information on it, so they definitely want to look at it.
There's a question here, does the GDPR cover data held on paper or just held on a computer? No, it covers all data held, we would have paper employee files here, and you see the big lever arches or your manila folders. That's all GDPR needs to be compliant with that as well. So if you're talking about your employee files again, and you have these big old lever arch, and somebody who's been with you 20 years, like Jenny's been in our company, which is bursting at the seams, I don't need all that information. So I'm going to have to go through it and delete a lot of that, shred a lot of that. And again, my personnel HR files, they have to be secure. They're locked down in a locked cabinet that nobody can just walk in and access them as well.
Somebody's asking there, is there a data checklist template available for small organisations? I think we'd refer back to the ICO website there, and there are 12 steps to preparation for compliance.
Yeah, they're doing a lot of work for small companies, and I said the helpline only went live on the 1st of November, and I think they're developing a checklist that's more suitable to small employers, but definitely the ICO would be the place to get that kind of information. Yeah, that's a question there. I think we answered that the first one about getting consent. So it's up to you to deal with your clients, and then they'll deal with their employees. Yes, there's a question there. Currently, an automated decision for a credit application does not have to explain a negative decision. Will this change now? Yes, this is what's happening when we talked about the enhanced rights for individuals. So where there is an automated decision, I don't know is it that necessary by default they have to explain a negative decision, but certainly the individual has the right then to go back and ask for that decision, or ask for some personal input and put their own slant on it as well.
If we use an external outsource outside of the EU, but their servers are in the UK, how does that stand?
I think that I don't know if I fully understand that question, but their servers are in the UK.
Well, then
it's fine to use it, it's okay. But there's a question of, we use Dropbox here in the office, and a lot of the Dropbox servers are not EU based. So there is a certain amount of our data. We don't tend to put employee data because that's all on our CRM, but our own internal, we don't tend to put customer data in Dropbox, but our own internal data would be on Dropbox, and that might be in the US. So it's not to say that we have to stop using Dropbox now because they have US servers. No, we don't have to, but we have to be extra vigilant that Dropbox are GDPR compliant. So what we've done there is we've gone on to Dropbox, we've spoken to Dropbox, and we've printed off and downloaded all their GDPR compliance, and I have to say Dropbox are quite good and they're quite on top of it, but we have that evidence there, and you can go on to people's audit reports and some of the bigger companies, their audit reports, to double check that they are compliant in these matters. And again, it's very important then that if you are using any servers that are saved, that are based outside the EU, that you're stating that in your privacy policies.
Somebody's asking there, is there a standard document accessible somewhere which we can amend to suit our business while ensuring our documents are legally correct? Unfortunately, there isn't. I mean, each company is going to be, responsible for ensuring their own kind of compliance. But like, if you go through, the slides that we covered in relation to kind of your inventory of what it is you need to do, do you require the information, do you require consent, things like that. It is really going to be down to yourself to do that. But
yeah, sorry, there's a few questions of the same. A couple of people have asked us, do we have sample contract wording? It's not something we have at the moment, and there, as I said earlier, there are specifics that must be in the contract. So it's something I've put on our to-do list that we might be able to work up something or give some more information. Certainly, as Jenny said, it's specific, and you have to be, it's very going to be specific to how you process your payroll and how you do it. But I've made a note that we can put it on our to-do list to maybe provide more guidance in this area, and hopefully we can get that to you over the coming week or so.
Again, the PowerPoint presentation will be sent along with a recording of the webinar to everybody who's registered for the webinar this morning.
Just another question here. When using BrightPay, is any of the employee data we input stored on BrightPay anywhere, or is it all stored locally to us as users? If we do store anything, where do we store it and does it go? So I think Jenny answered that question in the presentation. As a BrightPay user, it's all saved on yours. We
don't hold any data whatsoever unless you were to send us an actual backup or a snapshot of your information. And with our internal system now, if the backup's been sent internally from your own program, it means then that it's not coming on to our machines locally, and it is being deleted automatically after a week. So we don't hold any of that data, no.
Where customers are BrightPay Connect customers, we use Microsoft Azure server. So people who are using Connect, their data is backed up to Microsoft Azure, and our Microsoft Azure servers are in the EU.
I don't think you need to register with the ICO.
You don't need to register with the ICO. And again, when this comes into effect on 25th of May, the ICO and the governing bodies will be coming down and inspecting companies or going after companies straight away. I would imagine, a small employer is not going to be, or a small accountant is not going to be their priority. They're going to be looking after the Googles and the Facebooks of this world. And I think I read something recently that it might be something in the insurance industry as well with that kind of data. So I don't think we're going to be prime suspects here. But again, we don't want data breaches. Then we're going to raise to highlight ourselves even more. So you don't need to register, you just have to be compliant and just get your house in order really, and build up that folder and that defence is what I'd say.
Somebody's asked there, I use BrightPay Bureau Connect and also keep my payroll files in Dropbox, for example, as payslips, P60s. Am I good to continue with both, or should I move away from Dropbox? With the BrightPay Connect, as with the payroll itself, it is obviously highly encrypted. It is a cloud facility, so your documents would be secure. There is a document upload there as well if you, if you wanted to kind of upload items to it. But your P60s, your payslips, etc., they're all accessible on the BrightPay Connect. I would always be an advocate of saying you can never have enough security in relation to keeping your backup files and things like that. So I mean, once your Dropbox, as Laura's just said there, once it meets the requirements and is compliant in relation to being outside of the EU, and your contract is in place with them, I don't see why you shouldn't.
Yeah, and Dropbox Business, now we have a Dropbox Business account here, and my research is that it's fairly sound, but I definitely recommend that companies go in and print off that documentation and double check it for yourselves, because there are, again, within business accounts, there are different types of business accounts as well.
Yes.
But you just need to do that research.
Ashfaq, you're obviously one of those people who like to be safer rather than not safe. Unfortunately, we do come across those people who don't keep backups of any description, so fair play to you.
There is a lot of talk in payroll circles that GDPR may mean that payslips cannot be emailed to employees without specific permission. We're very much of the opinion that you can still email payslips. It's not why are you emailing payslips to carry out a contract? You're legally obliged to provide a payslip to employees. Certainly you can put in extra securities, and obviously BrightPay has all those encryptions and you can password protect your payslips, but we're certainly not under the impression that you're no longer able to payslips. We very much think that you can.
I suppose the option, like, I mean, at some stage I imagine the employees in receipt of paper payslips and were then given the option of being emailed the payslip. So they've given the email address for that to occur. So I don't know, would you need specific consent on top of that, or need them to kind of ratify that they do want them received by email? I think that's kind of covered really by them being in receipt of it already.
Yeah, yes, that's another question on that. If we send you a backup for help, is that now breaching data security? No, not necessarily. As I said, in our data privacy policies, we've clearly set out that we will take backups from customers, and we've enhanced our security around taking backup. So it's not a breach if it's been done and you're sending the data to a secure location to us. Why are we processing the data that you might send us? To assist you in completing your payroll, so that's fine. And what are we going to do with that data after we finish assisting you? We're going to delete it straight away, and we're not going to send it on to anybody else. It's just been accessed here once by the person. So we've set that out in our privacy policies, and we've added security around, as we said earlier in the presentation, security around how you might upload the data file. So absolutely not. It's the reasoning why, if you think about the why did you do that, the lawful processing, well, you looked for assistance in order to complete your contract with your client, or in order to pay the person. So certainly not.
Somebody's asked there, are we still able to send payslips via the post and password protect PDFs? I imagine posting payslips at this stage would be quite a serious breach of the GDPR, unless you had an envelope that was enabled whoever got it at the other end not to be able to open it. I mean, the facility now to email your payslips or just hand the payslip to the employee obviously would be preferable than to putting them in the actual post box. And your PDFs, as we said, like there's password protection on all of them, there's encryption within the software. So yeah, I think probably emailing them or just printing them and giving them directly to the employees would be more compliant in relation to the GDPR.
And it's not to say you can't do it, just that there's risks. And are you confident that you're mitigated all the risks?
Yeah.
Just another question there about electronic and paper files. So data that is kept in paper files, would we need to look at how that data is kept safe as well? Yeah, absolutely. If it's personal data, you're retaining it and you're processing it. The GDPR doesn't specify whether you're processing it in paper form or electronically. For the desktop software, is there an option for login and password? I'm assuming that for the desktop BrightPay. Yeah, absolutely, there is. Yeah.
Yes, you have the option of putting the password on, but it is something that we do highly recommend. Obviously, you're dealing with quite sensitive employee information, so we do recommend it. But I think you have the option of not putting a password onto it as well, and that's possibly something that we will default to for 2018-19.
How long would it be considered sensible to hold data after a client has left us? Well, you're going to have to hold your own internal accounts to be sure they're compliant with all HMRC requirements, and you may have passed on payroll information to the client, or you may need to hold on to their payroll information for the 3 years. So after that, then I would look to be removing it.
Are fines automatic if, for example, payslips were sent to the wrong email, i.e. human error?
Well, the files aren't going to be automatic. They're going to be, anytime you have a breach, depending on what that breach is, and you report it to the ICO, the ICO is going to investigate it, and they look at all mitigating circumstances. So it's not that they're going to slap on the 4% of annual turnover straight away. We can't say what they're going to fine you. It'll depend on the situation and on the case and what preventative measures had been in place and the situation around it. Okay, so I think we've got to a lot of the questions. A lot of people asking about the slides. Just one there, hi, what is the situation in the Republic of Ireland? It's the exact same. The GDPR is a European piece of legislation, so whether it's France, Germany, Italy, the UK or Ireland, the legislation is going to be the same. So very much we did this webinar on an Irish side a couple of weeks ago, and it's very much the same. We may have missed a couple of questions. I know some people have left, so there's no point in kind of responding to them, and I'm conscious of coming up on 12:30 now, so we don't want to go over time.
Yeah, I think a lot of these questions we've asked already. So
yeah, a lot of duplicate questions coming in as well. So listen, we'll sign off now, but we'll go through the questions again just to be sure that we didn't miss any. So if we did miss any, apologies, but we'll email you back later today. Thank you all very much for attending. I hope you found it interesting and informative and hopefully not too scary. But certainly have a think about BrightPay Connect and how it might assist you, and contracts in terms of your employee policies as well. So that's all for now. Thank you all very much, and we have a short questionnaire at the end and we'd love to hear your feedback with that. Thank you very much.
Thanks guys.